I gotta go.
I knew that many.
When?
Yeah, Alice, Fort Worth on.
Thank you.
That's a lot.
We're good, guys? Oh, we're live. Okay.
So,
Okay. So we are going to call the meeting to order. The time flew by here. I didn't realize we were already here. Okay, so let's call the meeting to order. All right. We have a roll call from Matthew, who's going to lead that, I guess.
Yes, good evening.
Good evening.
Sarah Glenville,
Here.
Dennis Scholl,
Here.
Jane Walker Payne,
Here.
Ed Stafford,
Here.
Russ Walker,
Here.
Donald Dale,
Here.
Robert Kuhn,
Here.
Kara Arena,
Here.
Sherry Richmond, and Rebecca Rayburn. Here. Wonderful, we have a quorum. Thank you.
All right. Okay, so the first thing on our agenda is a public hearing for the request regarding recommendation regarding several updates to the land development ordinance. Anna, thank you, is going to present for us.
If you pretend that W is a V, you'll pronounce it.
Okay.
Good evening.
Good evening.
You'll find in your packet some updates to our LDO. It's 2/3 main sections. The first one is Article 17. That's our sign regulations. In review, we found a lot of conflicting numbers, like a drive-through kiosk in one place said 12 square feet, and another it said 4 square feet. So we cleaned those up. There's some formatting changes. The main thing, it was all landscape, and now it's portrait to match the rest of the LDO, which is really nice when you're flipping through the giant book. And in general, just clarity to make sure that the general person looking at this sign ordinance will be able to understand it. Those are the main changes. I did make some changes from recommendations of the board since the packet went out. Those include, we updated the pictures for pole signs because they were pretty dated looking. Big concrete signs like you saw in the 90s for subdivisions. So just some cleaner, neater pictures. Also, since then, I removed the subdivision entrance section on the chart. It matches almost the monument signs, except for in height. But then in other requirements, it says, please use the standards for monument signs. So I wanted to make sure that made sense for either way. So those are the main changes for sign regulations. Are there any questions on that section? Yeah, Sherry?
I have a lot of questions.
Okay.
I guess there are places where it says temporary, and the temporary is not delineated. What is the time frame? Is it a week, a month, a year, 2 years? I think we could look at, for example, redoing some of these things, maybe at a different time frame. This is a lot to do tonight, but I have probably something on every page. Time frame was my main concern where it says temporary. Temporary signs including, but there's no time frame with some of this stuff. And that could be a distraction in the neighborhood if it's up for a year or 2 years. These are allowed signs. And then a question about only external illumination is allowed underneath the standards for the flags, but then it's not explained clearly, is that residential or not residential? So some of the things that are said are mixed or blended a little too much, where you'd have to read it carefully to know whether it's residential or not.
Okay. As far as temporary signs, I know there is a section in there specifically on temporary signs.
This particular one was on the flags.
Further,
Yeah, but the temporary, yes.
yeah, so for example, banners are permitted for 3 weeks and then have to go down for a resting period of 60 days. Is that 60 days? So that just keeps our streets clear of all those giant banners that get stuck up in other areas, not Jamestown areas. So as far as temporary signs, I do know that is covered as far as time frames. Flag lighting, I'd be happy to look into and make sure it's clarified.
So I guess some signs may not exceed 6 square feet, and I guess I'm wondering if we could go through this and look at streamlining or reducing even some of the choices for the pole signs. We have 5 different pole signs. Why not look at what's architecturally appropriate for future development and pick out what is best, maybe not have so many choices because you have so many different things going on.
That would be something that we'd probably need to put into the budget to hire someone to make sure
Hire
we're all
someone,
streamlined.
okay.
If that's something we want to look at in the future, it's certainly something to consider. But at this time, I think I'm just on the clarity of,
Okay, even with
You know.
timeframes, we couldn't have a hearing and clarify some of that.
I will ask.
Looking at another one with timeframe question.
As far as the temporary sign timeframe?
Let's see which one this one is. I've got it all throughout here, actually. Temporary event. Design and dimensional requirements for permanent signs requiring a permit, requirements for signs extending over pedestrian vehicular travel areas. Timeframe, I guess, was my question on that.
Again, I think that's covered in the temporary sign
Okay.
portion of that. I'm happy to go over it with you after, or,
I guess I just want to say that something that important that's visual, maybe we could use another hearing where we could kind of go over it a little more carefully and without hiring somebody, but make some small adjustments to that. That's just my thought. So I will leave that be.
any other questions on sign? The other section is Article 24, Nuisance Abatement, Property Management Code, and Minimum Housing Code. This is a big addition for us. There was previously not a minimum housing code or a non-residential minimum standards. So that has been written by Brandon Emery with Alliance Code Enforcement. He will speak to that in a minute of why he's added these and how they've worked in other jurisdictions he works in. I do want to note some changes from the packet, which are included in front of you. The scope was, Robert Kuhn caught that the ETJ was not included in the non-residential minimum standards, so that has been updated. And the wording has been changed to mirror, it did say minimum standard code enforcer, it now says planning director or their designee to mirror the rest of the ordinance. And finally, the only other change, I believe, is it has anything that's a commercial, has non-residential. A lot of it's already said non-residential, but it's just to ensure it doesn't necessarily need to be zoned commercial. It could be zoned Main Street, it could be institutional or industrial. We want to make sure anything is covered that's not residential. So that's why it's non-residential rather than commercial listed. With that, I'm going to ask Brandon Emery to come up and just talk shortly about that Article 24.
Good evening, everyone. So we were tasked with taking a look at the ordinance when we came in to see kind of what it looked like, if there needed to be any updates done to it, and if there was anything that we were seeing in some of the other jurisdictions that we were working in that may be applicable or maybe something that we could use here in Jamestown. We work in about 14 other towns right now, so we get a lot of exposure to a lot of different ordinance. The primary thing that we looked at with that minimum housing ordinance is what we had before was basically an unsafe structure. Minimum housing allows us to work on it in-house without having to get any type of building inspectors for the county to come in and do anything. It gives specific guidelines, requirements as set by the general statute to allow us to take enforcement action and provide the town the authority to abate it as they see fit, assuming we go through that proper process, which is outlined in that ordinance. One of the other things that the town did not have was specific ordinance dealing with non-residential structures or commercial structures. A lot of times that just tends to get overlooked just because, how many buildings you have. Sometimes they're newer, sometimes they're older, and you just, you don't think about it. So what it does is it allows us with kind of the commercial maintenance code and non-residential structure minimum standards, it allows us to take some enforcement action. Similar stuff to what we were doing with Article 24, but as it was kind of talked about earlier, sometimes there's some crossover between residential and commercial. So this just, creates a specific, divide, a specific line of saying, here are your residential standards, here are your commercial standards when it comes to that. So I think that's, what the primary purpose is of these ordinances. A lot of it was housekeeping, a lot of it was to do some updates through the 160D that came through that required some modifications to some things. And it just allows us to properly enforce the things that, the complaints that get generated in town that we hear. It allows us the ability to take enforcement action on those. And just kind of touch back on the sign. Friday, we picked up a little over 50 signs, so all of them were temporary signs. So we stay busy. We stay busy on that. But yes, if you have any questions about any of these, I'd love to address those as best as I can.
Does anyone have any questions for Brandon? Oh, all right.
Thank you. I
Thank
appreciate
you,
it.
Brandon.
Thank you.
All right, well, this is a public hearing, so we will open up the comment period. So if there's anyone who would like to speak on the matter of these two documents, please feel free to come forward to the podium and give us your name and address, and you'll have 3 minutes to speak. Okay, I don't see any movement towards the podium, so last chance here. Okay, well, we will close the public comment period for that hearing. And is there any further discussion we need before we have a motion? Yeah, Sherry, go ahead.
I was just doing the editing thing, this
Yeah.
retired English teacher. So I'm just going to put down a few little editing things for Anna. It's not going to change the sign ordinance at all. It's just pronoun agreement errors.
Okay.
Okay, just wanted to let you know that I'm going to do that.
Anything else? Okay. Would someone like to make a motion to either approve of these text amendments or to reject the text amendments? Ed,
I'd
yeah.
like to make a motion that they be approved.
All right, do we have a second?
Second?
Okay, Kara, seconded. Ed, did you get that, Katie? Yes. Ed and Kara? Okay, and this is a roll call, yeah, or no? Okay.
Sherry Richmond,
Yes.
Donald Dale,
Yes.
Jane Wilson Payne,
Yes.
Ed Stafford,
Yes.
Russ Walker,
Yes.
Dennis Shaw,
Yes.
Carolina,
Yes.
Robert Lee.
Yes.
Motion passed.
Okay, and Ed has a consistency statement he's going to read for us.
Okay, I make a motion that the proposed zoning text amendment be approved on the basis of the following. Number one, the proposed zoning text amendment is consistent with the adoptive comprehensive plan of the town of Jamestown. The planning board further finds that the proposed zoning text amendment is consistent with the comprehensive plan because periodic updates to zoning text are necessary based upon changing conditions, regulations, and laws. Updates establish town compliance with regarding bodies and ensure the guiding documents accurately operationalize the current goals of the comprehensive land development plan. Number two, the proposed zoning text amendment is reasonable. The planning board considers the proposed zoning text amendment to be reasonable because the report of the town staff finding the proposed zoning text amendment to be reasonable is adopted by reference. B, the planning board further finds that the proposed zoning text amendment is reasonable because the text amendments correct any previous errors and add clarifying language and formatting to make the documents easier to interpret and apply. And number three, the planning board considers the proposed zoning text amendment to be in the public interest because A, the report of the town staff finding the proposed zoning text amendment to be in the public interest is adopted by reference. B, the planning board further finds that the proposed zoning text amendment is in the public interest because continuous improvement to the guiding documents promotes consistent and equitable application of the regulations that promote the general health, safety, and welfare of the people of Jamestown.
All right. Thank you. Ed, did you get all those words, Katie? Every single one. Okay.
The paper
All right.
airplane.
All right, okay, so on to the next public hearing. We now have a Oh, shoot, sorry. Can we get a second on that? I forget that that's a second motion. Russ Walker, and we need to vote on that? That's just an all of those in favor. All those in favor say aye?
Aye.
Any opposed say nay? Okay, now we're good, yeah? Thank you, Katie, keeping us in line. All right, now we're on to the next public hearing for a rezoning request. And Matthew Johnson is going to speak first and introduce some other speakers for us.
Yes, good evening, members of the planning board. It is my distinct pleasure to welcome a couple of individuals here this evening. We're going to hear from them also following my staff report, but first, I'd like to introduce Tom Terrell. Tom is our land use attorney. He was hired by the town council to help us with this matter. And he does want to address the planning board briefly, and while he's doing that, I'm going to get our PowerPoint set up.
Okay,
Thanks.
wonderful.
Tom?
Thank you, Matthew. Pleasure to be here tonight. The matter that is coming before you in just a few minutes is neither routine nor inconsequential. And it's for that reason that I would like to provide a rather high-level view of where the planning board fits into this review process. And it's a role that it is defined by the statutes of North Carolina. Planning boards have been around for a long time. They are not new creatures, but they began to appear in this country at around the turn of the last century as cities started to adopt zoning laws. Their roles and authorities vary by statute, and they vary by city to city, but when you start describing what planning boards do, it's important to know that in North Carolina, you don't have variation. North Carolina is one of the very few remaining states in the country that follows what is called Dillon's law or Dillon's rule, which says that local governments are creatures of the state or the sovereign. Local governments do not have what is called the powers of home rule. So when we want to look at what the powers of a planning board are and the role of a planning board, we first have to look at the state statute. Now, Jamestown, within that statute, Jamestown is free to adopt its own meeting dates. It can adopt its own rules of procedure for planning boards. It can do quite a few things. It can elect its own chair and vice chair, but it cannot expand its powers. And I make this point because this is the question that has been asked to me 2 or 3 times in this process as to whether or not the planning board can do some extra things that it might like to do. And my advice to the town has been, no, we are strictly guided by what the statutes say. Given that, it is important for you to know that the planning board fulfills a vital role. There are at least 3 things that you do that you are dependent upon in this community to do. And the first one is the planning board is the keeper of the comprehensive plan. And by statute, the comprehensive plan starts with you. That is the community's vision. Before any change can be made in a zoning text, before any map amendment or what we call a rezoning comes before you, you have to look at it and comment as to whether or not it has general consistency with the comprehensive plan. Now, our courts have recognized, in fact, I have taken one of those cases up to our appellate courts, that you don't look for 100% consistency. In most cases, that's not possible. The vast majority of rezonings that come before you or in any jurisdiction, you have comprehensive plan provisions that are completely inapplicable, number one, or they are so subjective that it's very hard to nail them down. So it's general consistency that you're looking for. The second role that you fulfill is that you are the very first official review. you're the very first official sounding board representing the public anytime a text amendment or a map amendment is proposed in the town of Jamestown. And it's extremely common for those proposals to take a different turn when they leave the planning board than before they get to the elected body, in this case, the town council. That is extremely common. And number three, if the city's planning board statutes allows public input, and believe it or not, you are not required by statute to allow the public to speak at these hearings. But if it allows public input, it's at the planning board that the citizens typically first have the opportunity to speak into the process. Now, in Jamestown, you did something that in my 36 years of experience was unheard of. Laudatory, but unheard of, which was to have a public process informing the town and the town's advocate, Mr. Harry, as to what the town thought should be done with this process. Let me just go through a couple of things as to what the statute says before I turn this back to Matthew. The newly codified general statutes in North Carolina make it clear, and this is historic, that your role at this point is review and comment. That's the phrase that you see a couple of times. I'll read you two of these sentences. Subsequent to initial adoption of the zoning regulation, all proposed amendments or a zoning map amendment shall be submitted to the planning board for review and comment. The governing board is not bound by the recommendations, if any, of the planning board. And that's a limitation on your power. You have the power to recommend, but you don't have the power to control. Subsection D of 160D 604, though, talks about plan consistency. And it states very clearly that the planning board shall advise and comment on whether the proposed action is consistent with any comprehensive plan that has been adopted and any other officially adopted plan that is applicable. The planning board shall provide a written recommendation to the governing board that addresses plan consistency and other matters as deemed appropriate by the planning board. I emphasize that last sentence because you're not limited to plan consistency. If you wanted to send another message to the town council that you want them to consider this or look at that or consider any number of things, it is certainly within your prerogative to make that as part of your official recommendation. I thank you for your time. If questions arise, I'll be sitting here, but I'll be glad to turn this back over to Matthew.
Thank you. Are there any questions for Tom before Matthew introduces our next speaker? Okay.
Thank you.
Thank you, Tom.
Well, thank you very much, Tom. I also want to take a minute to recognize the gentleman that's here at the table with us. This is Seth Harry. I know that you're aware of who he is. He was our community planning advocate. He has been hired by the town council to produce a community engagement process, which we did in September, which we'll talk about a little bit as we go through this presentation this evening. He is also, part of his contract is to assist the town council as they go forward in reviewing the plans and the proposals that come before them. Also, I'm just going to tell you a little bit about how this will work. I'm going to do a little bit longer than normal presentation. During that presentation, when I get to the end of that, there'll be a time for Tom to come back and talk to you guys about some specific items. And then Seth will conclude our presentation. He'll talk to you a little bit about his role. And then the applicant's representative, Mr. Isaacson, with Isaacson Sheridan, will present. And then finally, we will open the public hearing to the public. So good evening, members of the planning board, and I do appreciate you coming out and spending some time with us this evening. It is going to take a little bit more time for me to do this presentation, but for good reason. We are considering a rezoning request for approximately 467 acres of land that was formerly known as the Johnson property, but is now owned by D.R. Horton. This is quite possibly one of the largest issues to come before the appointed and elected leaders of our town, and it just seems prudent to spend just a little bit more time bringing this case to you this evening. For several decades, the town of Jamestown has been preparing for this property to develop. While nobody's been aware of specific plans, it's logical to believe that the property would develop in some manner in the future, most reasonably because it's situated in a very growth-heavy area. Past leaders, the council, the staff, et cetera, in the town have smartly prepared for that eventuality. And the town of Jamestown and the city of Greensboro defined the areas of future growth in preparation for that in 1991 by signing an annexation agreement. And that placed the Johnson property, as it was known then, within Jamestown's right to annex. Infrastructure improvements and investments in water and sewer have been strategically sized to accommodate future development in the area. The 2020 land development plan, our comp plan that we were operating under until our most recent adoption of the update that was completed in 2007, identified this area as a potential for a traditional neighborhood development. And that means that that would be one with various types of residential uses as well as commercial uses included as well. The extraterritorial jurisdictional boundaries were expanded in 2008, giving the town planning and zoning authority over the property. And these moves were strategically completed, knowing that the growth pressures in the future would lead to development requests. Past leaders in Jamestown wanted to be sure that Jamestown had a voice in how the development would occur, rather than just simply allowing the county or the city of Greensboro to dictate the town's future on this particular piece of property. Let's see if we can get that. So this brings us to case number 2021. GIS at the county level doesn't quite compute to the same total that the survey does, but the survey is much more accurate. That leads us to 467 acres plus or minus in total. The proposed rezoning is from agriculture to planned unit development, or as we will say over and over this evening, PUD. recommended denial of the rezoning request in November of 2020, just 1 year ago, and forwarded it to the town council for their review. Recognizing the need for legal advice from a land use specialist, the town council smartly engaged Mr. Tom Terrell, who is a well-known and well-respected land use attorney and who has decades of experience working for both municipal clients and for developer clients. And we felt like that was a really good fit so that we understood both sides of the equation. The council felt that Mr. Terrell's experience would be of particular interest to the town, and they have directed him to assist the town in achieving the best development possible for the town. Your mayor and town council members have reviewed the application before them, and they had been keenly aware, watching the actions of the developer during the planning board's lengthy review of the issues, and felt that the applicant was not being reasonable in the request, and subsequently denied the rezoning based on its incompatibility with the town's comprehensive plan. Almost immediately, the developer attempted to use the North Carolina General Assembly to forcibly withdraw Jamestown's right to have influence over the development of this property by asking the General Assembly to remove our extraterritorial jurisdiction and to annex that property into the city of Greensboro. The mayor and the council fought back, and through a meeting with the Guilford delegation, they explained that Jamestown should have the right to properly vet development within its jurisdictional boundaries. With the denial of the rezoning request earlier in 2021, the town found itself in the very unique position that would allow it the opportunity to help guide development of this property. Typically, as I said, municipalities discover that the developer is interested in developing the property sort of late in the process. Often developers have options to purchase properties in place, have done quite a bit of due diligence, such as survey work, initial planning and engineering, and design work, and then they approach the municipality once it's ready to execute its plans. This puts us in the municipality in a reactionary stance. When the rezoning was denied in early 2021, the town council wisely began making plans to take a more proactive role in the design of the property. And certainly, not every single property warrants this type of approach, but the town council and the staff recognize the importance of getting this right. This is a very big piece of property and has a lot of potential to influence our community. So the town engaged with a community planner, architecture, and land design firm, Sathary and Associates, as I mentioned earlier, to assist with the public engagement related to the development of the property. The property was purchased by D.R. Horton in July of 2021, and the staff have been keeping them aware of our intent to engage with the public through the process with Mr. Herring. This was completed in September of 2021. Public engagement workshops hosted by Mr. Herring in September are just the first steps in the development process. The plans that Mr. Herring showcased during the design workshop reflect a set of principles of design that are intended to achieve a development that is sustainable, environmentally friendly, and desirable. And all of that information, all of the documentation and the videos and the outcomes and the products that came out of that can be seen on the website envisionjamestown.com. Under public engagement, there's a tab for Johnson Farm on there. The outcome of Mr. Herring's community engagement process was this illustrative plan. Anna's done a really good job of putting 11 by 17 versions at your table. This site plan is an illustrative site plan that shows potential development areas, and D.R. Horton has been keenly aware of this and has been listening and was at those meetings as a stakeholder and wanted to take the public's input and include it in their planning process. As you will see over the next few slides, the map included in your packet this evening, this one, that shows the bubbles of potential development, match Mr. Herring's site plan very closely. And I want to go to this particular slide. I'm very happy that Anna has a lot of technical expertise. If we can get this to, hang on one second, much more than me. There it goes. It is working now. As you can see, and it will transition back, this is showing the overlay of both Mr. Herring's plan and the plan that is in your packet from D.R. Horton, showing that the areas of potential development match each other very, very closely. So you can see it kind of moving back and forth there very slowly, and it ends with an overlay that shows that those areas match up almost perfectly. One of the questions that you may ask as a member of the planning board is, why is the PUD the right zoning district? In the past, a single-family home on a large, I'd say large, half an acre to an acre or more, size lot, was considered sort of the pinnacle of zoning. However, as the country's population grew, it became quickly apparent that this model is not really sustainable. Environmental impacts and encroachment on sensitive areas, water and sewer issues, and the overall consumption of land from that type of development has caused some observers to call for the use of land development techniques that complement or at least coexist with the natural state of the land. Studies have shown that neighborhoods that contain a mix of uses tend to be more desirable, sustainable, and less likely to succumb to urban blight and decay than those containing only one type of use. Thus, planners and developers, recognizing the need for change in the zoning ordinances to allow for those types of uses, began to utilize the planned unit development, or PUD, as a method to achieve subdivisions with greater design for sustainability. We understand that rezoning is contentious, and to put it bluntly, change is often pretty difficult. This project is not unlike many other rezonings in that it will lead to change in the area. However, the town is fortunate to have planned unit development zoning district, which is the legal authority, as Mr. Terrell said, to permit the town to have some influence over the development. So you may be asking yourself, how is this request different from the PUD rezoning request that came from Diamondback? And that is a very good question and warrants a close look at the process. The Diamondback proposal was for a conditional zoning plan unit development district, and this meant that the zoning conditions would have to be enumerated by either party and discussed in some detail. And planning board members may recall that lengthy meetings that we all discussed potential conditions, and the process is extremely cumbersome for a property of this size and a development that's this complex. Staff did recommend the use of a development agreement, but it was dismissed by the applicant. And I can't speak for the applicant, but we feel like this was probably because they were acting as a broker, and they were not the owner of the property, and didn't want to unnecessarily encumber the property by adding so many conditions to the development that it would be hard to market the property. This application that you have this evening is coming from the actual owner of the property. They have a vested interest. They purchased the property for a large amount of money, and they are interested in negotiating with the town to achieve a win-win. So the town council has been working with the experts that I just mentioned this evening, Mr. Terrell, Mr. Harry, along with the staff, to ensure that Jamestown achieves a high-quality development that will meet the needs of the current and future residents of our community. At the advice of Mr. Terrell, the town has requested that the developer consider the use of a development agreement to guide the development, and this document is a legal device that vests certain zoning rights to the developer while subjecting the developer to a list of terms and conditions which are in the interest of the community. North Carolina law limits the use of these agreements to relatively large projects which have moved beyond the conceptual stage and into a relatively detailed planning stage. The cost of developing such an agreement are often much greater than the conventional zoning requests, but they're very effective tools where the investment of such time and money are warranted. Development agreements are useful tools for collaboratively addressing major development proposals, and D.R. Horton has willingly agreed to provide the town with a development agreement and will work with the public and the town council to craft such a document in subsequent hearings with the town council. Another question that you may ask yourself as a planning board member is this consistent with our comprehensive plan? As you're probably well aware, many of you served on this committee, the Envision Jamestown Steering Committee and Comprehensive Plan was part of a nearly 2-year process to update our previous comprehensive plan. And while staff had been discussing and planning for the update for quite some time, the funds were allocated by the town council in the fiscal year 1920 budget to begin work on the project. And the timing was to coincide with the North Carolina General Assembly's update to the statutes which govern municipalities, which is 160D. And the council allocated some additional funding to assist with the update of the land development ordinances, LDO, during that process to ensure compatibility with the new law. It's also important to note that the town has been diligently working within the scope of its abilities to ensure that public facilities and services are adequate with regards to the proposed growth resulting from the proposed development. The town has already initiated several studies or has participated in studies with our strategic partners to help address issues of solid waste, water and sewer, schools, police, and fire protection. The results of these studies will be compiled, and the town council will utilize that information when reviewing the development agreement with the applicant. Every effort will be made to include all of our partner agencies in these discussions. The most recent comp plan was adopted just recently in October at town council and will be the governing document for the planning board and the town council as they consider this and other future rezonings or until another update is adopted. The updated comprehensive plan, which was adopted, has several guiding principles which may relate to the rezoning request before you this evening, and which the planning board and the council may utilize to help decide on whether or not this zoning request is consistent with the plan. The first guiding principle that we feel like is important to review is guiding principle number 1. Jamestown, and that says Jamestown will actively facilitate high-quality growth that is both compatible with the town's traditional development pattern and innovative in how it meets the needs of our diverse and dynamic community. There are several notations under each of these guiding principles. I'm not going to read all of those. I'm just going to highlight the guiding principles themselves. Guiding principle number 2, it says, as the strength of our community is directly tied to the long-term success of our neighborhoods, we will work diligently to promote and maintain the quality of life and aesthetic standards that our residents expect in Jamestown. Guiding principle number 4 says the ability to walk safely and ride a bicycle throughout the town is critical to maintaining our community's high quality of life. We will ensure that our community is well connected with the necessary infrastructure to support walking and biking as an important mode of transportation for all residents. Guiding principle number 6, every neighborhood in Jamestown will have a convenient access to a wide variety of public parks, natural open spaces, and other recreational opportunities that meet the diverse needs, abilities, and desires of our residents. Guiding principle number 7, the town will continue its tradition of providing cost-effective and efficient public services and high-quality infrastructure that meets the needs and exceeds the expectations of our community. Guiding principle number 10, Jamestown is a welcoming and inclusive community that values the benefits of diversity in all aspects of the town and its residents. And finally, guiding principle number 11, the quality and health of the natural environment is as important to our community as the quality of the built environment. And we will work to preserve and protect these vital resources. The Envision Jamestown Comprehensive Plan, or as I'm just going to refer to as a comp plan, indicates that the property in question is located in our preliminary growth area. This designation is primarily based on the availability of water and sewer, which I mentioned earlier is available, its development ability, and the fact that Jamestown already exhibits zoning influence over the property as it's located within our ETJ. The comp plan also calls out anticipated future land use. And the steering committee, the staff, and the public were well aware of the possibility of the development of this property since Diamondback had already asked for it. So we had a unique opportunity to discuss that with the comprehensive plan consultant, Benchmark Planning. So they spent quite a bit of time surveying the public, engaging committee members, assisting the planning board during the initial rezoning request, and otherwise planning for the eventuality that this property would be developed. And out of that planning process, the final plan calls out this parcel as the Mackey-Guilford land use category. That district is defined as follows. The Mackey-Guilford future land use classification is applied to the largest single undeveloped property in Jamestown's planning jurisdiction. As one of the premier potential development tracts in the Triad, this property is expected to experience significant development interest in the near future. Given the size and prominent location of this tract, the town is expecting a development plan for the site that is designed in a manner to create an integrated, walkable, and mixed-use neighborhood that contains a wide range of housing options, a central community focal point where residents can easily access neighborhood-scale retail, dining, and service uses within a short walk or bike ride from their homes. With an abundance of land resources, it is expected that the future development of this tract will provide significant amount of open space for both recreational use and the preservation of critical habitats that exist on the property. It's also expected that the development of the area will preserve the most important aspects of the historic landscape, connecting the past to the future. And the resulting development of this area is expected to yield a complementary and enduring addition to the Jamestown community that respects the history, character, and aesthetic quality of the town. While reviewing the current zoning tools available to the town, the envisioned Jamestown Comprehensive Plan on page 66 has the following to say about the Plan Unit Development District. During the development of the plan, the town also adopted a new Plan Unit Development District that's intended to be used as a tool to permit the design and development of innovative and integrated neighborhoods on a larger scale than can be adequately regulated by the conventional regulatory structure of the general zoning district. Such developments will typically include a wider range of housing types than is typically seen in most conventional residential neighborhoods, and will generally include some non-residential uses in a centralized area that's connected to the overall development. Plan unit developments will also typically include an integrated transportation network with robust facilities provided for bicyclists and pedestrians, along with significant amounts of open space and recreational amenities. So this brings us to what is the decision that is before the planning board this evening. We have two items to consider. First, is the plan unit district the correct zoning tool? Is it the proper vehicle for us to consider the development of this property? And second, is it consistent with the comprehensive plan? And the staff have reviewed the request for rezoning. We unquestionably feel that it is consistent with the comprehensive plan. And we would request that the planning board recommend the rezoning request favorably to the town council with the understanding that a development agreement would be negotiated in a public hearing held per the state law prior to annexation or rezoning of the property by the town council. And as I promised, Mr. Terrell is going to come forward, speak to you a little bit about development agreements. Mr. Harry is going to close with some information about his role in the process. We stand ready to answer any questions, but I'll let the applicant speak and then the public. Thank you.
Thank you.
Thank you very much.
I said in a meeting earlier today that this is a big boy project, and it's time for everybody to put on the big boy pants. I have never seen such a small town rise to the occasion as the town of Jamestown has done in putting its big boy pants on, and I say that with great admiration. When I started practicing law in the 1980s, the rule was that you cannot do anything that remotely resembles or that looks like what was called contract zoning. The reason was because zoning is an act of legislative power, and a government is not free to contract away its legislative powers. But that invited a process that was as idiotic as it was chaotic, where a developer or property owner wanted to invest, in some cases, tens of millions, hundreds of millions of dollars into a community. But they're put into this process where they're then limited to 15, maybe 20 minutes to speak at a public meeting that's guided as much by emotion than it is by facts and reason. Fortunately, we have evolved, and one of the ways that North Carolina did evolve was the adoption of legislation in 2005 that allowed us to do what is called a development agreement. It was a huge step forward to impose some sanity in these processes. Development agreements, as Matthew just said, are ideal for large-scale, long-term, multi-phased projects. That's the best time. Now, you don't have to be. The statutes have actually been recently amended to allow their use in smaller impact projects, but this is where you actually want to have a development agreement. A development agreement does one thing that we never had before, and that is to create a figurative table where everybody who has a voice in this process can sit and talk and work out all the details that flesh out what we would otherwise be doing by zoning. Now, this does not supplant, it does not replace the rezoning or the rezoning decision. The town council retains those powers, the town council retains those responsibilities, but a development agreement gives them additional powers to go deeper, to go further, to go beyond what they otherwise could do. It is something that enables a town to, in a very rational way, look in more details. For example, I've done several development agreements, and most of them are pretty thick. But they start off with recitals, like most any agreement might do. They allow you to define your own terms for the agreement. They give you the opportunity to create development standards. Now, the PUD will have its own development standards, but that's the first layer, and that's the first layer that you typically get in a rezoning. A development agreement enables us to negotiate and to work out the path by which those standards will be implemented, what happens if they're not implemented, things like that. It allows us to put in metrics. The most important thing, probably for a development agreement, is that it creates a trigger point. Instead of just saying the developer is required to let's say, to build a road or a turn lane, a development agreement allows us to say by what time and on what conditions do you have to be coming forward to make this expenditure. It defines it. So now is the time. It also helps a town like Jamestown to budget its capital outlays, because many times you have obligations that are incumbent upon the town to make something like this possible. Well, these require budgeting. A development agreement creates that connective tissue that enables all of these parts to work together. Who provides utilities? Who oversizes utilities? How are these utilities served? This is why we have it, and you might be interested to know they have enforcement mechanisms built into them. They are not, although they are probably started out, they always start out with lawyers sitting down, creating a template. They are done with broad input, and most importantly, by statute, the development agreement is made public long before the public meeting. So it is a public document, it is a public record, it must be adopted by ordinance and after a public hearing. Now, when we get to that point, more likely than not, there will be a combined public hearing on the rezoning and the development agreement, but it'll have to be adopted separately. And anybody who wants to come up and complain about the placement of a comma, how a principle has been developed in the agreement is free to speak. Now, I'm hoping that we have some opportunities for enough input that all of those misplaced commas and dangling participles are caught before it becomes a public record. But it will be looked at by many people, and I am hoping that it will provide a path and an outline that will keep this project, if approved, moving forward in a way that enhances the character of this community, that protects the functionality of this town, rather than doing the opposite. Glad to answer any questions, yes.
Is there I guess, or is the development agreement a living, breathing document, or is it, once it's gone through the public hearing process, that's it? And that serves as the guiding document for the next 10 years, regardless of what comes down the road over this 10-year plus
Let me
project?
address the embedded question first, which is how long do they last? They used to have a 20-year cutoff. That has just been changed to say they can last for whatever reasonable time under the circumstances. More likely than not, it will be incorporated into the zoning conditions so that it lasts and runs with the land as does the zoning. But is it breathable? I think you mean, can it be changed? Yes. The statutes allow for two types of modifications, a major and a minor. A minor modification must be defined in the development agreement itself. Statute doesn't say it. It just leaves it for the town and the drafters to figure it out. But if it's a major modification, which might be, and I'll just throw this out hypothetically, the intensity, the use types change, in some defined way, then you have to come all the way back through the town council for another public hearing. But a minor modification can be made in other ways defined within the document.
So the document itself outlines the actions should either party not follow through with what's agreed upon.
That is correct.
Okay.
Yeah, and to clarify that, with that situation or any other, you can't depart from something the ordinance absolutely requires you to do. You can go beyond it. If the ordinance says it's $100 a day fine for violating it, you can go beyond it and say it's $250 a day.
Thank you. Other questions for Tom?
Thank you.
Thank you, Tom.
Seth's on his way up.
Thank you, Matthew, and good evening. In anticipation of and preparing for the next phase of this process, I had started to, in our role in supporting both the town and Mr. Terrell's work, I'd started to outline some tools and techniques for translating the input that we received from the community during the public design workshop in September into a set of guiding principles similar to what Matthew explained, but these will be derived specifically from that process and the documentation that it produced with the intention of memorializing basically the community input and state preferences that we gathered from that process, and with the relating to specifically to the planning and design of any proposed development for that property moving forward from this point forward, because that was really its intent. It was to sort of capture what the community's input and preferences were based on that outreach and engagement process. The purpose of this was to use those principles to develop a more detailed set of design standards and criteria with which we can objectively determine if and to what extent any proposed plan meets those standards. And making it principle-based gives us the ability to kind of go back to the source. And so if there's any discussion or conflict between what the potential standards or guidelines, or I should say criteria, are relative to what those original principles where we have the basis to make those modifications as needed, but it also gives us some flexibility. And by doing this, we would therefore have the ability to confirm whether or not those, that proposed plan expressed those, the preferences of the workshop participants and the community as a whole. So it's a way of kind of translating the images that you saw earlier this evening into a more concrete and specific and objectively defined set of guidelines with which we can evaluate any proposed submissions relating to that property. We believe, and I agree, in our experience, that this approach will afford, a principle-based approach will afford both the applicant and the town, on behalf of the community, the flexibility to efficiently negotiate the terms of the development agreement relative to those specific issues, and also with the flexibility to allow those to be interpreted by both parties based on the priorities of those of the individual parties, and hopefully to the mutual satisfaction of both. That's the work that we've already started, and we are in the process of compiling those principles and defining how we will translate those into those objective standards and criteria. It's a work in progress at this point, but I'd be happy to answer any questions related to this particular approach and its relevance, both to the work of Mr. Terrell and the town in negotiating the development agreement. Thank you.
Thank you, Seth. Any questions for Seth?
I know.
Yeah, go ahead, Karen.
Yes, just to clarify, so the principles that came out of the engagement session, you're saying will potentially go into the development agreement to help guide?
Well, the principles are almost a little bit, they're kind of the equivalent of the intent language. It's the source material, and it's derived directly from that workshop. And the intent is to make sure that all of the participants, all of the residents and community members who participate in that process will have a voice through those principles and how they're expressed specifically in those guidelines and criteria.
So, and I don't know if this is a question for you or for Tom or for the developer, is there a chance that those principles will be completely left out of the development plan?
Well,
The development agreement?
they would be left out, at the risk to the applicant. I mean, the point is that it gives us a tangible framework with which to represent the community's position based on that workshop, based on the outcome of that workshop.
So Seth, and again, this may be a question for Tom or Matthew, the folks working on behalf of the town to get the content into the development agreement that came from what your team did in the workshop, is it the town council members who are creating that language that goes into the development agreement, or is it?
I think that's a question for you.
Tom, maybe it's Tom who creates the language, or?
Yes, but they approve it. Are they creating it? Is that your question?
I'm sorry, what was your question to my question?
Your question is whether they're creating the language or
Yeah, I guess so. We the Seth's team, had a very extensive, comprehensive process that really engaged folks. Now, who makes sure, who are the people who actually make sure that what he did gets into that development agreement? Is it the town council members? Is it you? Is it the town staff? Or?
Yeah, your first line of either offense or defense, depending upon your perspective, is me.
Okay. Thank you.
How, and again, this might be another question for Tom. So we've got two questions before us, whether the PUD is appropriate, and then if it meets the guiding principles of the comprehensive plan, if it's consistent with the comprehensive plan. If we do not know the contents of the development agreement, which will be basically the definition of whether it meets the comprehensive plan and those guiding principles, I understand how we can vote for the first part, whether the PUD is appropriate. How can the planning board recommend that it, or state that it is consistent with the comp plan if we don't know the details that will define that?
None of the details that would be in the comp plan are touched upon in the comprehensive plan, such as who pays funds at what point, how you deal with utilities, the standards that you would have for arrangement of homes. Those aren't details in the comp plan. Those are the details you would have in a development agreement. I do think you will find, however, that after you have heard Mr. Isaacson explain how they are approaching this and what guiding principles will be incorporated from the D.R. Horton team, which the development agreement will then flesh out, I think you might see it differently, but let's wait and see if that is your perspective.
Can I ask a follow-up to that? And it might be more appropriate after the developer presents that. But is there anything that's saying that the developer is going to do that for sure at this point in the process? Because they could present us a lovely presentation of ideas, but what they present tonight could be very different than what ends up in our development agreement, right? It could?
Yes. There are two, let's call them stopping points that would prevent that from happening. Number one is your town council members. That's your first defense against them going off the rails and doing something else. And then the second would be the fact that the voters would probably run the council members out if they allowed D.R. Horton to do something completely opposite than what was proposed here. There is a level of trust in this process. There is some integrity in this process. And you have people whose professional reputations are on the line, and they are coming before you, and they're saying, this is what we're going to do. And then you have professionals, and you have an elected body who is here to make sure that it does happen.
Tom, so can I ask to just, for my own clarification to Robert's question, so my understanding of what we're voting on is not does the development meet the, or what's the language?
The agreement,
The-
development agreement.
No, not even the development agreement, that the ultimate development, not that that is, what's the language that it?
Consistent.
Consistent, thank you, that it's consistent with the comprehensive plan. Is the PUD as a tool for development consistent with the comprehensive plan?
Yes.
For instance, if D.R. Horton came today and said, we would like to rezone it from agriculture to industrial, we wouldn't necessarily need to know the details of what that industrial plan is to know that that zoning is not consistent with the comprehensive plan.
That is correct.
Okay.
But you're soon to hear how they are going to be filling in some of the blanks with this PUD process. And I think that how your questions about that, I'm hoping, will be answered to a great extent at that time.
Okay, thank you. Any other questions for Seth or Tom or Matthew or anyone before we hear from the applicant? Thank you. Okay, so, is it Mr. Isaacson? I don't have my agenda in front of me. Is it Mr. Isaacson who's going to be presenting? Is that correct?
Yes.
Ah, thank you. All right, yes, Mr. Isaacson.
I drew the long or short stick, depending on how you look at it. Can you all hear me okay through this mask?
You can take it off.
Okay. Okay, great. Well, good evening, everyone. Madam Chair, members of the board, I'm Mark Isaacson. My address is 804 Green Valley Road in Greensboro. I'm an attorney there in private practice. A couple of preliminaries. First of all, I served as chairman of the Greensboro Planning Board for about 5 years, and so I know the unenviable task that you all have every month of reviewing text amendments, plans, rezoning applications, and the like. And so I've been there for many, many years.
For whatever reason, after I rotated out, the city council in Greensboro dissolved the Greensboro Planning Board, merged it with now the Planning and Zoning Commission, so draw your own conclusion as to what kind of job we did. And also, a great deal of respect for my colleague, Mr. Terrell. We go way back to days in Chapel Hill as students and together, and so always a pleasure to work with Tom, and you've got a real professional representing the town in this matter, so you should feel fortunate that he took on this project. I have with me this evening quite a team that we have assembled. Folks from managers from D.R. Horton are here, 2 civil engineers that have been working on the project, along with others that are deeply involved in and have been working with the town as a team to bring this project to Jamestown. As you heard, D.R. Horton acquired this property earlier this year as it determined that it needed to work directly with the town of Jamestown to determine the ultimate destiny and future uses of this property and to ensure that it would fit well within the town of Jamestown for decades to come. And we've since then worked closely with the town staff and its consultants and professionals to develop this or craft this application for a planned unit development. As you've heard, the PUD ordinance provides the type of flexibility that is intended to accommodate a large area, such as the Johnson Farm, and to allow a very creative approach to using time-tested as well as modern principles of development to provide quality housing and amenities to serve the people of Jamestown in this community. And while there are several minimum standards that will apply to the PUD, the ordinance allows quite a bit of flexibility, as you've heard. And when you matrix the PUD zoning with the development agreement that we've agreed to enter into, it creates a very flexible but very creative opportunity to develop this unique piece of property. The PUD that we've applied for will allow quite a variety of housing types. So we would expect, for example, that there would be developed on this property fairly conventional single-family detached housing. Also, single-family attached housing. Also, what would be known as, I guess, lock and leave type of housing, which is virtually no maintenance and a little closer together than the other types of housing that might be developed, that would be developed here. And finally, what we would characterize as reasonably affordable but high-quality multifamily housing that would cater to younger adults or downsizing adults who might have a need for that type of housing. In addition, there would be some amenities on the property, for example, light retail, a coffee shop, that type of thing that would be walkable or bikeable. And in addition, we have been working with Shauna Moore, who's here this evening as a historical consultant for the project, and who has been doing research on not only the Johnson family, but on the property itself and the history of this property. And we anticipate having a community center which will have historical artifacts from the family and from the property. The Armstrong House is of keen interest for this company and for this team. And we have really delved into this deeply, and so we look forward to having photographs of the family and of the farm and of the operations from days gone by in order to preserve that history and tell the story of the Johnson family and their ancestors in this community. And I might add that, a little personal touch, I knew Ted Johnson very well. My dad was the chairman of the airport authority when Ted was the director at the airport. and I think they talked with each other about every day. And I was able to work with Ted and his team on several airport matters in practicing law with my dad and working with Ted. So it's a story that has a lot of meaning for me personally, for our family, and so I was elated and honored to be asked to work on this project for their family property. The LDO defines a planned unit development as intended to accommodate a range of uses and to encourage new development and infill development in a manner that accommodates a range of uses while preserving historic development patterns and being sensitive to the adjacent districts. In return for greater flexibility in site design, PUDs are expected to deliver exceptional quality, community and site design, and preserve critical environmental resources, provide high-quality designs for community amenities, incorporate creative design in the layout of buildings and circulation, ensure compatibility with surrounding land uses and neighborhood character, and provide greater efficiency in the layout and provision of roads, utilities, and infrastructure. So that's a mouthful about what a PUD is intended to do. And I think you'll see that we intend to accomplish that. Now, we understand that the purpose of the Planning Board's review of this application is to evaluate the application in light of the purpose of the PUD under the ordinance, and to make a recommendation to Town Council about the merits of the application in that regard. We've worked for several months with town staff and its consultants to design an application that is supported by the ordinance and that fits within the parameters of the PUD framework. As the staff report mentions, we have a bubble map that you all may have seen. You may have a copy of it here, this green map. And I think Matthew showed you that how it overlays well and matches up well with the map that Seth's firm produced from the charrette process. So the uses that would be included, as I mentioned in this bubble map, the PUD, would be conventional single-family detached homes, attached single-family homes, that is townhomes, multifamily homes, and light commercial uses, as well as the community center that I mentioned that would preserve and respect elements of the history of this property so that residents may continue to learn about the important historical role that this property and the Johnson family and their ancestors played in the development of Jamestown over many decades. You might note in the plan that we have, and this, if you all have a larger version, this table down at the bottom, a little difficult to read sometimes, does outline the various uses for which the property may be utilized in different areas. Now, there is some flexibility that's built into this table, and that's needed because we are just starting out on a long, long process of this development. This is really the first big step. This review by you all as a planning board in determining how to recommend this going forward is the first of many, many steps for this process. But we have, through our engineering, preliminary engineering, outlined or determined where certain uses ought to go on the property. And so you'll see that, and that's about as much specificity as we can provide at this point. Now, why is that? You know, I'm a problem solver, so is Tom. We love figuring things out quickly and answering and getting results. Unfortunately, that's not the way land development works. This is a large, large piece of land. It's also challenged with a lot of issues. What are some of those issues? Well, number one, there are a lot of streams on this property, and we've got to honor and respect those areas and be careful and sensitive to those. There's quite a bit of topography challenges on this property. This is not a square 10-acre parcel of land that we can just sort of come in and chop up in cookie cutter style. That's not going to work here. So in addition to streams and topography, we've got access points that need to be determined. So that's a big variable, and those have not been determined yet. So we've got an access point that we're hoping we can achieve in one part of the property, and I've been getting, let's say, less than really happy phone calls from the D.R. Horton folks saying, well, what are we going to do about this? How do we determine the access here, and who do we have to call to nail that down? Well, you know, that is part of the process. So we will be answering to not only the town of Jamestown and the staff and the technical review committee process, but about 5 or 6 other review agencies, such as NCDOT, the NC Department of Environmental Quality, DEQ, the U.S. Army Corps of Engineers will have oversight here, as well as Guilford County. And of course, we'll be going through the rigorous process of review of the plan with the town of Jamestown. So we're just starting out on a long journey. It may take over a year to get through that process in order to get a final result, a final plan that everybody can look at and say, okay, this is exactly what's going to go where. And so, as Tom and Seth and Matthew have outlined, we're not coming before you presenting architectural designs or what kind of mailboxes are we going to have. There will be a homeowners association that governs architectural review, and that will be able to enforce those principles that would maintain those high standards for this property. But we're a long way from that. And so what we're talking about is what type of zoning should apply to this property going forward, and what are the terms of that zoning, namely the site-specific plan that we're presenting. That's as specific as we have, but it does meet the definition of a site-specific plan so far under the ordinance. We've cleared that with Tom and the staff, as well as submitting to or subjecting to this development agreement, which we've agreed to do. In addition, we've done something, as Tom mentioned, that's a little out of the ordinary, and that is we participated in a public charrette process where we listened and we learned. We listened to the residents of Jamestown. We learned what the priorities are and how would we meet the standards that this town has set over many decades. And really, that's what this is all about. So that's how we hope to move forward. So we have worked, in summary, we've worked closely with the town staff, its consultants, and legal counsel, and we've listened carefully in at least 5 public charrette meetings to file this application for PUD zoning. And we would submit that PUD zoning is the most appropriate zoning designation for this unique and special property. We pledge to continue to work closely with all stakeholders to develop a high-quality, mixed-use community that will be part of Jamestown for many years and that will be a point of pride for all citizens and others. One point that was brought up that we should mention is what's called under the LDO, the PUD ordinance, permitted residential density. And I wanted to address that. Again, we are very early in the process. And so it's virtually impossible for us to give you a number. I would love to give you a specific number, but it's virtually impossible to do that based on all the variables that we have mentioned. What I can tell you and commit to the town is that our residential density will be consistent with the principles in the comprehensive plan in Envision Jamestown, and we will abide by that. And so that will be another factor that will be subject to this extensive and rigorous review that I've mentioned and that you all are well familiar with. So I did want to mention that because it came up late in the day today. I am happy to answer any questions, but more importantly, I've got a great team of folks here that are a little more knowledgeable about some of the specifics about the property, and so I'm glad to bring them forward with any questions that you all may have. And again, very much appreciate your attention. Yes, ma'am.
And this may be a question for some later presenters, but, you know, the planned use in the land use description is great. The alternate use, I think, has a couple of concerns in that 8 out of the 10 areas could potentially be commercial, right? And I don't know if you can say this, but what is the likelihood? I think that would be kind of the worst case scenario, right? Where 8 out of those 10 spaces would become commercialized areas.
I think we
Will you address that in a couple of minutes, or?
I'll be
You know.
glad to, and I'll also be glad to ask Bob Dissinger, our civil engineer, to address that as well, why that was characterized that way. But essentially, we built in some flexibility in the plan to allow different types of uses in different areas, depending on those constraints, those factors that I mentioned, the streams, the topography, the access points. You know, if there's an access, you really want to put the more intense development near the access points, and that's what we intend to do. But those haven't been determined yet with any kind of certainty. I would submit to you that D.R. Horton is not a commercial developer. They're a residential developer. They bought this property in good faith with a vision of developing this property for primarily a residential community, a mixed-use, primarily residential community. And so I think that this is the beginning point for that plan. We do have some flexibility built in, but the clear priority here is for a high-level mixed-use residential community. I'll be glad to ask any one of our team to come up and address that further, but thank you for the question.
Are there other questions? I think Sherry has a question for you.
Ma'am.
Yes, and this is related to your question. I asked it in a discussion with Anna Haverlock, too, and she explained it very well. And that, yes, 8 out of 10, I noticed that, too, were optional alternate use commercial, which was kind of frightening for us. And she explained that, similar to you, but hers was just made more sense to me, that if this can't be done this way, it would be flipped, and something else would be flipped. So it's the alternate use, but that piece would be flipped from residential to commercial, but it doesn't mean all of them would. It's just they want that option to do that. Does that make sense?
It does,
She
and
did a great job with that.
Very glad that you got a clear explanation.
Yeah, that helps, because I would argue that, you know, if we look at just the alternate use description, it would not fit our comprehensive plan. And I realize that, I guess I'll just end it with that, right? If we were to look at what the alternate use was, if it were all of those spaces being commercialized, I don't think that would fit our comprehensive plan.
Very well,
But the planned use,
well understood.
we'll talk about it later.
I would also add that the way I understand the process will work here is that by the time we get through the process of town council review and the development agreement, we should have those areas nailed down. And so that will be subject to a public hearing, as Mr. Terrell mentioned, on all of that, so that I would submit to you that if we came in with 8 out of 10 areas as only commercial, you might find us out on the interstate heading out of town. So, I don't believe that will be the case.
Matt, I have a question maybe that you could answer that's related, but I know that the designation, the PUD designation is not necessarily very specific, but I know you read it to us, but I think it's a light commercial use. At some point, wouldn't extensive commercial use mean it was really commercially zoned and it was not meeting the definition of a PUD any longer, and then that would?
I think the key word in the ordinance is compatible. I think that it's got to be compatible with the residential in the community. After all, once hopefully we get through the review and approval process, which is rigorous in and of itself, these folks have made a tremendous investment in this property, and they're supposed to go out and build and sell this community to people who want to live here. And so I like the natural sort of economic forces that play in something. We have this great regulatory framework that applies in the world of development, and we all deal with it every day. It's a very heavily regulated business in and of itself. But what I think really matters is, can you sell it? And,
Right.
And so if D.R. Horton in this case, or this example, builds something that you wouldn't buy or you wouldn't buy, it's just not going to work. And so what I think a nationally ranked company such as this is going to do is uphold its reputation and its credibility as a first-class builder of residential communities. And yes, I think they intend to have some light commercial that will serve, I think it would be more like support of the residents in the area so they can walk to or bike to some supportive services. And I mentioned a coffee shop or cafe, maybe a yoga or Pilates studio. What do folks who live in this community, what are their priorities? What are their preferences? I think we heard some of that during the charrette sessions. And so that's the market. And that's the market speaking, and that's what we're going to listen to. Okay, well, thank you all very much.
Thank
and
you.
We're available
Thank you, sir.
for questions. We appreciate your time.
Thank you. Does anyone, before we open it up to public hearing part, does anyone have any more questions for anyone who's already spoken? Okay, let's open up the public hearing. So if there's anyone here who would like to speak regarding this topic, then come forward to the podium and give us your name and address, and you will have 3 minutes.
I take my cues from Katie.
So do we.
Tom Turvo, 2 Langholm Court in Whittington Hall. I've attended all of the meetings with Seth, and so if you were any of those, you probably heard some of my comments. I'm all for the PUD. I do believe that gives Jamestown as much control as you possibly can. If I were to summarize my concerns, and hopefully you'll have a chance going forward, the devil is in the details. Absolutely it is. I worry a little bit about safety. In the plans that I saw, both driving and mostly driving, but some pedestrian safety, I'm not sure was adequately planned in those plans. Driving is a big deal. You get a wide street, that's a through street, and particularly younger people are late for school or whatever they are. My suggestion for a solution is a roundabout, but and moderately wide streets. Another suggestion that I don't like anywhere near as much is narrow streets. Just saying. The emphasis on commercial. Any direction you go from Jamestown now, there are shops, there are grocery stores, and there are empty storefronts. Anything we put in that is going to compete. And so fewer commercial properties makes more sense to me. I did not see or hear anywhere near enough recreational emphasis. Recreational area. A community center where the people, I mean, you've got, all that acreage, all those houses where people can meet, maybe have a little reception, et cetera, et cetera. I happen to prefer also a community swimming pool, which we have in Whittington Hall, and it's a wonderful attraction for younger children. Housing density, you've kind of touched on that. You put those houses all together, there is an environmental defense for that, because you're not using so much green space. But housing density, well, you understand the consequences. I have a little one-page summary. I'm going to give it to Katie, and I hope you'll ask for it and take a copy of it.
Okay.
Thank
Thank
you.
Thank you.
Thank you, Tom.
Okay, anyone else who would like to speak?
Oh, great, I'm Norma Marshall. I received a letter. I don't have a packet, but I received a letter. I wanted to come tonight to be here. I'm at 21 Gatehouse Lane, and the side of my house is right by Mackey Road. I'm near the bridge, and I've been lucky over more than a decade to have the Johnson farmland as my backyard. And I have appreciated it every day. So this is sad for me, but it's coming. So I have a list of disadvantages, concerns about the property and the construction, and some ideas as well, questions. So I'll be brief, and I just won't go over everything. But the disadvantages due to the loss of acres of forest and soil erosion. The loss of natural beauty is so important for our well-being. And this is, every country in the world knows this. Everybody, this is topic number one these days. The loss of trees adds to toxic runoff on hardscapes into streams, causing water pollution, which also adds cost. It's also going to be costly for the county to regulate and treat. And I'm wondering, will Guilford County Commissioners perform land management analysis prior to and during development to preserve numerous diverse trees and plant life, improving soil structures with higher levels of organic matter that have greater resistance to erosion, and investigate water quality? Will these things be done? Are they in the plans? Oh, well, that's what I'm wondering. So that's very important. And if the PUD increases the risk of the flood risk, and we have to purchase FEMA insurance, will the developers help us with this cost? Just thought I'd say that. So smart landscaping, it's the easiest way to increase property value is to, and to speed home sales, is to have a diversity of trees and beautification as well. But also trees filter pollutants like lawn fertilizers, pesticides, and other chemicals in the landscaping. And diversity of trees and plant life minimizes the risk of one particular pest being able to run roughshod over neighborhoods. So this is important. Wildlife habitat is going to be endangered. I haven't heard anything about that. I have a feeling I'm going to have all the wildlife that's going to be in our decks and coming into our homes. But will Guilford County Wildlife Commissioners provide analysis and direct implementations on lessening the effect of the losses of the wildlife?
I'm sorry to interrupt you, but your 3 minutes has
It's up.
expired. Yeah, it goes fast, doesn't it?
Do any of you need, or I just give you? Okay.
But that, yeah,
Thanks
wonderful.
for listening to me.
Thank
Thank you
you.
very much.
Okay, anyone else who would like to speak tonight? Okay. Last chance here. Okay, I don't see anyone else, so we will close the public hearing. and deliberate. So did you all have any questions, comments, discussion points that we wanted to go over before moving forward with a motion?
I've got a couple.
Yeah, let's hear them.
Under the LDO and the planning, under the PUD specifically, there's a question, there's two items that the planning board is supposed to consider and recommend onto the town council that I don't believe has been addressed. I appreciate Mr. Isaacson's comments about density, but that is one of the requirements that we need to recommend as part of this process. The other, and I honestly cannot figure out why we are responsible for this, but signage. We're supposed to recommend, after a review of the signage shall demonstrate compliance with the Jamestown LDO, except that the standards can be varied if the master signage plan is submitted for review and approval concurrent with the site-specific master development plan and is reviewed by the town staff, recommended by the planning board, and approved by the town council.
I can address.
Please.
Yeah, please, that'd be great.
One of two things could be done. Number one, you could ask Mr. Isaacson to come back to address the issue of signage. If that is not done, by law, the signage defaults to what's already in your ordinance.
Okay, what about you said we were required to consider density?
Permitted residential density is to be submitted as part of the overall site-specific master development plan, which shall be reviewed by staff, recommended by the planning board, and approved by the town council.
We discussed that. What that ordinance provision does not say is they shall come before the town with a number. It doesn't say how that density is to be presented or developed. What Mr. Isaacson just said, as I heard, was that it would be a density completely in conformity with what is in the comprehensive plan. If you wanted to ask him further about that, you could also call him back up for that.
Thank you, Tom. Barbara, did you have more, or is that?
Let me let other folks talk for a minute. Consider.
So, Sarah, I appreciate your clarification on what we are voting on tonight, which is, right, is the PUD consistent with the comprehensive plan, and is the PUD appropriate? My biggest concern with this process and what we are faced with tonight is if we're looking in the packet under the suggested timeline for consideration, it specifically says that the planning board will not negotiate the terms of the development agreement. And I have concerns about that, and I don't know that there's anything we can change in regards to our vote tonight. But the planning board is, I think, the biggest place where ETJ members have a voice. And as the property sits most closely to much of the ETJ, this is our opportunity to voice our concerns with the development. And yet we are not a part of the development agreement process, other than through the public hearings, which is fine, but, you know, we're limited to 3 minutes, and as people have demonstrated, that's not a very long time to speak about concerns, right? And we can email our council members, but as ETJ, we also don't get to vote for the council members. So, like I said, I don't know that there's anything to be done. I don't know who decided that the planning board doesn't get to negotiate the parts of the development plan. But I think it was not a great decision. Right, I don't know that we need to get into all of the nitty-gritty details, and based on the light commercial description, Ed, I'm still looking forward to our ice cream date.
Yeah,
And have
that's
an ice
right.
cream shop.
I want to buy your first code now.
Thank you, that's right. But, yeah, I think that is maybe something to consider as we are making our decision. If possible.
One comment I'd also make is that I think Mr. Isaacson mentioned that the TRC would be involved in the development of the agreement. And this is ignorant on my part, and please forgive me, but who is the planning board member on the TRC?
Well, maybe someone from the town staff can answer that. Art Wise and I used to attend the TRC, but has not happened in a long time. Art Wise clearly is no longer with us, so.
I'd be glad to address that. So many years ago, there was some development issues that came up where the planning board would recommend one way, the town council would vote another way. There would seem to be a little bit of miscommunication between the two bodies. So at that time, the then mayor, and the then chair of the planning board and I went to the School of Government in Chapel Hill and actually went to lunch with David Owens, who's one of the gurus, if you will, of planning and zoning at the School of Government. And a couple of things came out of that, that meeting. And the very first one was that they recommended having a liaison to serve from the town council to be here at the planning board meetings to listen in and see what's going on. And one of the second things was that there could be a liaison that would come to technical review committee type meetings and that type of thing. If you look at the ordinance, technical review committee member that comes from the planning board is not a voting member. They don't have any influence or input over that, and that's for a reason. The technical review happens at the staff level, and it simply means that they are complying with the law. In our case, that's the land development ordinances, or in this case, it would be that they are complying with the language of the development agreement. Certainly, we welcome to have liaison come. Sometimes it's inconvenient because we do work during the day, and a lot of you do work during the day as well. So welcome that capacity, but again, it's not an influential type thing. It's really just a watch and listen type of role on the planning board. Its intent is to foster communication to make sure that that the planning board understands what processes the staff have to go through as well. Thanks.
Thank you, Matthew. And I will confirm that when Art and I attended, we would listen and learn a lot of things that we didn't know about. Art knew much more than I did since he worked in construction, but. And I don't know, Tom, I don't know if you're the one to ask or who, but I mean, I think Kara brings up a very good point that the area of town that's most affected by this development has the least representation in the, what's it called again?
The development agreement.
The development agreement. And is there a way to address that?
First, I don't accept the premise that this is the area of town most affected by the development. Now, a process.
I guess visually affected, I should say. Visually affected.
They may be closer.
Traffically affected.
They may be closer in proximity, and I would accept that there is a geographical approximation, but a project like this has impacts, and impacts that are mitigated much broader than those who live across the street. And that's part of what we have to look out for here. Now, no, the statute does not give the planning board any input. The statutes say the development agreement is negotiated by and approved by council as an ordinance, and a planning board does not have ordinance-making powers. The planning board duties were not written so that they had input on development agreements. Now, you do have an input as a citizen. The public hearing may have a 3-minute limit, but I can assure you that once it is made public, as is required by law, and will probably be made public for a longer period of time than the statutes require, we will receive and we will read and we will digest any written comments and any other comments. I invite you to participate in that. I don't want to build your hope that it's going to be a fun, easy read. It's a document that you may want to put it by your bedside table.
You're speaking to an English major, it's all right.
But you are certainly invited to read it and comment as you wish.
Thank you, Tom. Oh.
Quickly, if you don't mind. Do you know what the lead time is for publication before the,
For publication,
publication of the
30 days
30 days?
for a development ordinance, development agreement, yes.
Okay. That's prior to the public hearing.
Yes, I'd have to look at the statute specifically to see what it says, but it's a 30-day.
And now, I'm probably stepping into maybe something you were going to ask, which is that the statute doesn't say that the planning board is a member, right, or a part of that process, but it doesn't not say it either, correct?
A power granted to a government must be expressly given. If you want to write down some of the cases, I can cite you to Landville versus Cabarrus, Quality Oil versus the town of Carthage. There are many such cases that say expressions of power must be explicit. Yes.
I want to address that issue a little differently, and I know it's been discussed in a meeting, but maybe it's good to say it here. Someone told me a long time ago that perception is reality. And the ETJ areas, the perception is that, as to some people, is that we no longer have a voice because we are not being able to make some decisions here in this public place. I'm talking about perception. Because there's no ETJ representative on the town council. I know that's law, but I'm talking about perception. The largest, most important development will occur with no ETJ input, from what I understand, unless it's the public input 3 minutes at a time. So the average citizen or person in the major ETJ area, which is Cedarwood, about 800 plus or minus citizens, are in the perception, or some may be in with this perception that they're being left out, and yet they are directly across from this. So yes, what goes on over there, hopefully blended with single family to blend with single family, and not have commercial on a corner there, but perception is, do we have a voice that we used to have on this, because they could watch these videos, they could give us input, they could communicate with some of us, call us, email us, hey, I really like that idea, or what do you think of this? So I want the perception to shift somehow to that you're going to take care of the ETJ perception, that the ETJ people will be represented, they will be heard. There's a big gulf here, and I want to cross that.
Let me address that. In 2013, I led the effort in North Carolina to rewrite a statute that had been on our books since 1919. It was the ordinance that authorized boards of adjustment. It really had not been touched much in 90 years. But how we did it was we democratized the process. And we took all of our drafts and sent them to land use attorneys, planners. Mr. Johnson, I'm pretty sure, received a copy of it. If he is on any of the listservs at the School of Government, people spoke into that process, and every time there was a change, it was actually footnoted, so that it was transparent. I don't think that we could do a footnote change here, but we did the same thing when I chaired the state committee that drafted the current land use and planning statutes that govern how we do land use and zoning in North Carolina. Every change was footnoted, and every time we had a new draft, it was posted on websites, it was sent out to various stakeholder groups, and it actually strengthened all of those documents that we were working on, because when you democratize, you do get ideas and suggestions you would not have thought of. Now, it's harder to do that for a development agreement because you don't have equal application like you would to, in an ordinance. You have it's a negotiated document. And that negotiated document has one key stakeholder, which is D.R. Horton, that has to have a key seat at that table. But as to how the public is looking at it, I will tell you that once we have a template for that has a lot of meat to the bone, I have no problem with that being made available to the public for comment. There may be things that cannot be put in, there may be things that would not work, but you get no resistance from me. I don't ultimately control that decision, but I would not mind it.
So would this be a legal possibility to look forward in the future to having that plan brought before the planning board for comments? Is that anything that can happen?
It possibly.
Not a vote, but just for comments, or I really like this, or our area really appreciates this part, or could you shift this one? Is that a possibility for the
It
whole
is-
board to look
I
at?
mean, interrupt, doesn't it?
Sorry.
It is a possibility, but I am hesitant to make any commitment on that because it is outside of the statutory framework. If it comes back to you as a member of the planning board, I want to be able to say to the town of Jamestown, when this thing comes to the end, whether it is approved or denied, it is a decision that is legally defensible because we did it the correct way. So that causes me to hesitate about creating a non-statutory input for that.
Thank you. My idea sounded great, but it doesn't work very well when you explain why it wouldn't work very well. So thank you. Thank you for explaining that.
Mr. Isaacson's behind you. I think you wanted to say something.
I'm always behind you, aren't I? This is a little unusual, but we've been listening to the concerns expressed by the members of the board from representing the ETJ, and we were discussing that briefly. Sorry. I'm sorry. We were listening to your concerns, and, we've been listening to concerns and questions throughout the charrette process and through the other parts of this process. I probably have to work this out with Tom to make sure that we're on legally sound ground, but we would like to invite the members of the ETJ for another listening session, let's call it, where we would hear, we think you are impacted by this development, and we would love to hear your concerns as we move through this process. And so to the extent we're able to do so and still be legally defensible, we would love to work that out. Please bear that in mind. Thanks.
That's a great idea if it's workable. I think you have some very nice people here who would have some helpful suggestions, and it would also help pull these two communities together. I don't like this polarization idea that we have talked about.
I think
Thank
you'll like to see the buffers and the other natural areas that are going to be left open as a result of the EUD process and what I mentioned about flexibility and engineering. You'll appreciate the way that a lot of this area will be left natural and open. There will certainly be development on the property and streets installed and other building and infrastructure, but that's going to happen. And so we'd love to get the input that you're mentioning to the extent that my learned brethren over here will allow it. So thank you.
Thank you.
Thank you.
Thank you, sir.
Thank you.
And if I may, just as I'm not in the ETJ, so maybe I'm speaking out of turn, but I think a lot of the concerns that the ETJ members have are the same concerns that folks who live in Jamestown proper have, but there are unique concerns as well. For instance, I think of the last time we went through this, for me, as someone who lives over here in Forestdale, I wasn't really thinking necessarily of the street lighting, because what I see is I need street lighting to go out running in the morning, not necessarily considering the impact into the home. So it's those kinds of things where the ETJ, I think, has some different insights that they can share that wouldn't necessarily come out organically from people who live in Jamestown proper, is my thought, but. Okay, other questions or comments, or? Okay. Did you, okay, I couldn't tell if you,
No, I would like to make the comment that, I was not part of the planning board when Diamondback.
oh, gosh, you missed out, Robert.
I did miss that board. And I would commend the staff and the town council for the process that has gone to this date. It is, I think it's been much more open. It's been much more collaborative, and I do appreciate D.R. Horton's offer to allow the ETJ members to participate further in the comment and development of the development agreement. I do think the PUD is the way to go, so.
Agreed. Thank you.
Well, I'd like to make a motion.
All right, Ed, let's hear your motion.
My motion is that the planning board recommends approval of the zoning application in case number 21-02, subject to the following items. Number one, the site-specific master development plan submitted to the planning board shall be approved by the town council. A development agreement shall be approved by the town council. The permitted residential density will be as determined by the town council as part of the site-specific master development plan and subject to a development agreement. And any variance in signage, excuse me, from the LDO standards shall be approved by town council and subject to the development agreement. That's my motion.
All right, thank you, Ed. Is there a second to that motion?
I second it.
Okay, Sherry, beat you to the punch, Dennis. All right, this is a roll call, is that right?
Yes.
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 Yes. Yes.
Yes.
Yes.
All right, thank you. And now, Ed, I think you're going to read a consistency statement for us, the word I couldn't think of earlier. Consistent.
Yes, I just think of these things in my sleep at night. I'm a happily married man. I try to be consistent with the plan. I make a motion that the proposed zoning amendment be approved based on the following. The proposed zoning amendment is consistent with the adopted comprehensive plan of the town of Jamestown. The planning board further finds that the proposed zoning amendment is consistent with the comprehensive plan because the 2020 Comprehensive Land Development Plan adopted Plan Unit Development PUD as a zoning tool available to use on large parcels of land to promote and encourage pedestrian-friendly traditional neighborhood land use patterns and development. I got some water they haven't used.
I've already used mine.
All right.
He's got some.
Number two,
Here you go,
the
Ed.
proposed, thank you. Thank you very much. Number two, the proposed zoning amendment is reasonable. The planning board considers the proposed zoning amendment to be reasonable because, A, the report of the town staff finding the proposed zoning amendment to be reasonable is adopted by reference. B, the planning board further finds that the proposed zoning amendment is reasonable because the property in question is part of Jamestown's, quote, preliminary growth area, end quote, due to its size and location, and the PUD zoning designation allows for regulated growth that meets Jamestown's goals and needs. And number three, the proposed zoning amendment is in the public interest. The planning board considers the proposed zoning amendment to be in the public interest because, A, The report of the town staff finding the proposed zoning amendment to be in the public interest is adopted by reference. Number B, the planning board further finds that the proposed zoning amendment is in the public interest because the PUD zoning designation provides for oversight and regulation by the town staff and our elected officials to ensure any new development meets the goals and guiding principles of the comprehensive land use development plan, including, but not limited to, making smart growth decisions that maintain and enhance Jamestown's special community characteristics, preserving Jamestown's natural and historic resources, and keeping Jamestown a welcoming and inclusive community.
Thank you, Ed.
I submit that to you.
All right, does someone want to second that motion?
I'll second it.
Thank you, Robert. And this is just an all those in favor, right? All those in favor, say aye.
Aye.
Any opposed, say nay. Okay, the consistency statement has passed. All right, thank you, everyone. And now, Matthew, do we need the consideration of the date for the next regularly scheduled planning board meeting?
Yeah, just a quick note, we will be convening at the December regular meeting date, which is December 13th, if I'm not mistaken, as the Board of Adjustment. We have had a variance request come in. We are working to process that, and we'll have information out to you shortly. Just wanted to let you know.
Okay, thank you. And the Board of Adjustment does not include the ETJ, is that right?
That's correct. It'll just be the 5 regular members of the board.
Okay, thank you. All right, and sorry, Dave, you had something.
Y'all might be surprised, but Katie may not be with us. She just told me today that she was expecting.
Well, you caught me off guard.
But I did want to introduce Nancy Avery. And Nancy is from Curry Beach, and she is a certified municipal clerk with many years of experience. And she will be filling in for Katie until she returns to us.
Wonderful.
And so I just wanted to introduce Nancy.
Hey, Nancy.
And I was shocked today that Katie, and we may have others.
I think if Katie is with us the next meeting, she's going to have some serious discussions with her doctor. Nancy, are you going to be commuting all the way up here? Or? Whew, good for you.
We're going to use the town helicopter.
Oh, well, welcome, Nancy. We're glad to have you. That will be for a short time, unless Katie has some other decisions she wants to make in life. So we'll cross that bridge later. Okay. I think we had a couple people sign up for public comment.
I'm not sure if they actually want to speak during public.
Yeah, they may have spoken already. I'm not sure.
And then James nobody else.
They decided they didn't want to talk to us after all. Oh, all right. Well, it looks like we've come to the end of the agenda then. We need a motion to adjourn.
So moved.
Thank you, Russ.
It's always good at that.
Dennis, you want to second it?
I will second.
All those in favor say aye. Aye. Any opposed? Say nay. All right, we are adjourned.
3 strikes.